We are broadcasting live to YouTube, so just even though the hearing hasn't started, I want you to be aware of that so that you're not saying anything you didn't want on YouTube. I believe the judge will be joining us momentarily. She just sent me an email, so I know she's at her desk. I am recovering from an illness, so I am working remotely. So the judge and I are not in the same place at the moment. But I have every reason to believe she's going to be with us momentarily, so hold on. If I heard correctly, we may not be going forward with a full hearing today, but I'll leave that for the attorneys to talk to the judge about. I won't say anything to her about that. I'll just see what the attorneys announce. Also, hold on. Okay. I don't think anyone requested a court reporter. If you did, raise your hand. Okay, I didn't think so. That's all I was really checking to make sure before we got underway. All right, hold one moment. I expect the judge momentarily.
Good morning, gentlemen. How are you?
Good morning, Your Honor.
Good morning, Your Honor.
Good morning, Judge.
Good morning. So thank you all for being with me on relatively short notice. I've seen a flurry of emails and document attachments. And before we get into that substance, here's why I wanted to have a status conference. As I understand this case, I'm going to tell you what I understand where we are procedurally, and then I'll give you a moment to tell me if any of that is incorrect, because it may matter. As I understand it, this was originally a dispossessory action that was filed in magistrate court. The magistrate court entered a dispossessory order, which are pretty standard, that require, granted a judgment in favor of Habeas Properties, saying you can get a judgment for back rent and you can have your dispossessory. Mr. Wimberly filed a timely appeal, which requires that he pay money into the registry of the court to keep the case going. And then the parties, because of the appeal, ended up in my courtroom, and there was a motion for an injunction to prohibit there was essentially an agreed injunction to prohibit acting on the dispossessory at that point. Am I good so far? Yes, Mr. Habeas.
No, Your Honor. When Mr. Wimberly went to file the appeal, the magistrate court rejected the appeal because the money he paid into the court was actually he paid with an NSF check.
No, I'm aware of all that, Mr. Habeas, but that all happened after the fact. The appeal itself got filed and got assigned to me based on.
There was actually 2 NSF checks, Your Honor.
In any event. So first of all, Mr. Habeas, do you have counsel?
Your Honor, I'm his counsel. Craig,
Okay.
let me be talking for you. Thank you, Judge.
No, and I don't mind hearing directly from Mr. Habeas because he's got, he's definitely the one probably with the most walking around working knowledge of this fact. I just wanted to make sure I wasn't stepping over an attorney if he had one. And Mr. Reynolds, you're here on behalf of Mr. Wimberly, correct?
That's correct, Your Honor.
Okay. So Mr. Habeas, your point though is sort of where I get a little confused in reviewing the record to figure out where we were today, because after I entered the injunction at the parties, essentially the parties' agreement, the idea was the parties were going to resolve, they thought they were going to be able to resolve the case. They essentially, as I understood it, agreed to a temporary delay, which was embodied in the form of that temporary injunction. And then it was brought back to my attention when the funds in the registry of the court that had actually been paid and accepted, about $16,000, setting aside the fact that perhaps the clerk of court perhaps should have discovered non-sufficient funds sooner than a month or so after they were submitted, maybe 2 months. But setting that aside, that was how it was brought to my attention. And it was brought in the form of a motion for contempt, which of course requires a hearing before I would take any action on any such request. But in the process of looking at the case, what I don't understand is absent my injunction, which was an agreed injunction for which there is now no longer agreement. So we have to revisit that issue. What I don't understand, and Mr. Reynolds, I'll throw this out to you. My understanding of the applicable Georgia code is that if you don't pay the money, then you lose the protection of the dispossessory. Now, the parties would still have to subsequently later go and attempt to enforce any money judgment that they think they're entitled to, but you lose the protection of the not having the writ of dispossessory acted upon. And that's sort of where I was getting to every time I looked at this case. I wanted to have a chance to talk with you guys about what the situation is. Mr. Reynolds?
So I believe that the Superior Court, with its powers, would have the ability to stay the dispossessory action under its equity powers and the agreements that were in place, regardless of that issue. Is a short
No,
answer.
and I'm not disagreeing with you, but that's not really my question. My question is the orders that the magistrate court judges enter, and then the notice of appeal that a person files to appeal a dispossessory judgment. They both contain language that references a Georgia statute that very clearly says you have to pay this money into the registry of the court, or the party who's been granted a dispossessory is entitled to an immediate dispossessory. I understand that separately you can ask the Superior Court to stay execution on that dispossessory, but I'm just trying to figure out if we're all in agreement that there is part of the problem here is that the money's not been paid, and in the absence of that money being paid, Mr. Wimberly is not protected from the execution on the dispossessory absent action by the Superior Court. Is that?
I think you're correct about that, Your Honor. In short, the answer is yes. Obviously, the issue here is that we didn't want to be in a position where he's paid money into the court registry and paying money to the landlord here.
Right. But my understanding in looking at the paperwork that you guys have submitted, that part of the agreement, I think that's outlined in some of the emails, is we won't ask for anything out of the registry if you make good on the payment that you were going to make to us as part of the injunction. Right. And that has not happened yet. The payment has not been sufficiently made to Habeth in any form, as far as I'm aware, either through the registry or through.
That's where we kind of disagree about, and that's why we're here contesting the matter. I mean, you are correct that as we sit here right now, Habith Properties, the landlord, does not have all of the funds. They do have some of the funds still, and the issue is that they've rejected the remainder of the funds, but they were paid.
Okay. And that's where we get into the sort of substantive factual dispute that I think we need to have. I was just trying to figure out where we are procedurally. Go ahead, Mr.
If I may.
Yes, please.
On the same point that you raised, there's ample case law, in fact, to the effect of if compel orders and what comes out of OCGA 44-7-53 is not abided by the tenant, automatically, as a matter of just law, even without the discretion of the court, the tenant loses possession rights to the premises, as you stated somewhat a little earlier. Even in some of these case laws that have looked at this matter in a little bit more detail, they've looked at, pursuant to case law, again, OCGA 44-753-54, that upon a motion for writ of possession or possession to be handled, failure to pay, as a matter of just this question of possession, goes away automatically. And that's 180 App 431. 349 SE2D 284, Your Honor. It's a 1986 case, old case, but still a good case. It's my understanding that in this matter, Your Honor, and this was at the time that we were not representing Habith Properties, and I understand that Craig perhaps has a much better understanding of the scope of everything that has gone on. But it's my understanding that at some point there was inducement to enter into a promise to pay and stay, but that promise to pay and stay never happened. We've submitted some documentations from a third-party objective entity, the Law Enforcement for Fulton County Police Department, Atlanta Police Department, which they have found probable cause to pursue this matter as a matter of check forgery and check fraud.
To that around here.
Hang on, Mr. Reynolds, I'm going to give you an opportunity to respond. I will say I have seen that allegation in your pleadings, and I understand that Mr. Wimberly has a different characterization of what's occurred, but go ahead, please, sir.
And again, I do fully give him that benefit of the doubt, and that's between Atlanta Department, the solicitors, and the DA's office, and him to, later on in a criminal proceeding to, figure that out. For my client's purposes, all we're seeking today, Your Honor, is for the injunction to be lifted, because we do have this matter on the September 5th in the actual dispossessory calendar that it was brought on. We're trying to reinstate the writ. And I think parties would have ample opportunity to go over all the evidences pertaining to the actual payments, the consent order that was reached, in that separate action. For purposes of, where this matter kind of, got out of, we don't see any, further need for having the injunction on the basis that the injunction was based out of promise to pay. The consideration never happened. We do have the magistrate court hearing that, is coming up. We do want to get the writ of possession on this issue. Now, nevertheless, Mr. Reynolds and I may work something out before that. But I think, for purpose of today's purposes, all we're asking, Your Honor, is for the injunction to be lifted.
Okay. Mr. Reynolds?
Taking issue first with the Atlanta Police Department reference that was made here. I did reach out to that detective this morning. I wasn't made aware of that letter until late in the day yesterday. I have not heard back from him yet. Obviously, as the court is aware, and pursuant to the documents we've submitted, we have a different interpretation of what occurred there in that point. However, I think that's hearsay anyway, and I don't think the court should consider that factor. As it pertains to the issue of the payments and the registry in the court, we made a decision to try to honor the agreement that had been in place between the parties pursuant to our last hearing. Mr. Wembley, of course, did try to submit the payment. The payment was rejected, it appears, for some reason. It appears, and we can ask Mr. Habib about this specifically, but based on the email that I saw that he provided, he was on the phone with Navy Federal. With the consent of Mr. Wembley, they together spoke to the bank officials who confirmed that the reason that the check was delayed, the reason the check was bounced is because there was a delay in the deposit. There was a deposit made. And remember, this all started because on that date, on July 5th, I think it was, we had what I consider to be for lack of better terms, an unreasonable demand that payment be made that same day within an hour or so. He had to bring down a check, but he tried to do that. He went and got the transfer. He got a loan from somebody so he could have funds in that same day. Once the loan was made into his account, he was able to issue that certified check. And then he presented it to them within that literally same day time period. The fact that there was a delay or a hold placed on that deposit and the bank gave him that check anyway is not something that he had done willfully or improperly. He had every right to suspect that once he made that deposit and the bank issued him that check, that he had provided them with a sufficient check. I'm still not aware. I haven't talked to Navy Federal yet to be able to determine what that hold was. All I know is I was mentioning to co-counsel a moment ago is that, and I'll just share my screen with you so you can see this particular document I'm referring to, but I was notified by my own bank that there was something affecting banks at that time period. And it didn't only involve Bank of America, but it said other banks may have been affected as well when we had a transaction around that same time period here. So we know that he issued them the check. He tried to honor that check. He did provide them with it. There was some sort of delay in the deposit, which Mr. Habib was aware of. He heard it, that the deposit was not cleared in time for the certified check. Why they gave him that check anyway, I could not tell you. Why they didn't just clear it or push it.
That is one of the questions that doesn't make sense, right?
Right.
The purpose of a cashier's check is that it's basically the same as cash.
Exactly. But again, Mr. Habib himself acknowledged Mr. Wembley spoke to them and let him be on the line. He didn't hide from this. He said, let's call him, let's figure this out. Furthermore, we have communication that was made between Mr. Wembley and the banks to try to resolve this issue. He's been trying to make the payments and he has made the payments. He's tried numerous ways to try to make the payments to honor that agreement. And so if the issue here is whether or not he did something willfully or did something that was, malicious, or even did something that he had control over, the answer to all of those questions has to be no. He did try to make the check bounced, but as I said, he let them talk to him. They said it was a delay. To me, that sounds like there was some sort of hold on the account, perhaps, that Navy Federal did not take into consideration, or that it was affected by the same thing that my Bank of America notified me about, being a delay that affected many banks and their clients. Regardless, we know that Mr. Wimberly then tried to still make payments with them. And I think this is an important fact here, because even after that date, Habib Properties agreed to still accept the funds. So this idea that the funds did not arrive on the 5th, or there was some sort of problem with that, after that phone call, they were satisfied, at least it appears, that there was valid grounds for them to try to accept payment after that date, and allowed him a chance to, they altered essentially the date.
Right, but Mr. Reynolds, let me interrupt you. So, part of the reason, though, that I wanted to have this status conference is because it's September the 1st, right? Setting aside the request for contempt, which I was not intending to and do not intend to entertain today, because I don't think that I will entertain it if that at an appropriate time, if that's what the movement of that motion wants me to do. But my review of the file seemed to indicate that this was about payment, setting aside, pushing aside all of this issue of did he pay, didn't he pay? If he didn't pay, was it an error by the bank, or was it some intentional action by him, or whatever? Move all of that away. And at the end of the day, it's September the 1st. And Mr. Wimberly still has not paid. And my understanding is that procedurally, he's not entitled to continue to pursue his appeal and be protected against dispossessory unless he makes the payment, either directly to the landlord or into the registry of the court. And neither of those things has happened. And that's what I'm trying to get to is that has not happened. And I don't know that it necessarily requires the court to determine if there was an effort that failed or why that payment has not happened. I think that the answer is either the payment has happened or it hasn't happened. Yes, sir, Mr. Reynolds.
Thank you for raising that point. The payments did happen, though. That's the main issue I have with this whole motion that was filed. There's this effort to cry wolf and to say that he didn't make the payments or he was committing some sort of fraud. They got the payments. They returned them. They have the payments and they returned them voluntarily. If you look, the payments that were made here, you can see that they were rejected. He made payments.
Hang on, Mr. Reynolds. Hang on. Look, I'm going to ask you to stop your screen share for just a moment because I am going to hear from Mr. Please forgive me. I don't want to mispronounce either of your names. First of all, I keep calling you Habif because I used to do work with Habif Arrighetti and Wynn when I was a lawyer. Is it Habif or Habif?
You got it dead on, Your Honor. You're one of the few.
So Habif is right.
Correct.
Okay, thank you. And sir, how do I pronounce your last name?
Sure, Nematbach, Your Honor.
Nematbach. I'm sure I mispronounced that, but I appreciate your kind gesture in not correcting me.
That works, Your Honor. Thank you.
Okay.
Your Honor, I appreciate Mr. Reynolds' advocacy in terms of working towards a good faith efforts that the tenant perhaps has made. But none of those matter, Your Honor. This is not based on how well they tried. It's more so, did they get it done or not? Did they?
Well, I don't disagree with you, but let me make sure we're having the same conversation. So when he says they've gotten the payments, that's the part. He showed me one example of a $10,000 payment that was refunded. But what payments has, and by payment, I mean actual money that would be honored by the bank. What payments has Habif received?
Yes, Sean, I'm happy to go over that. So there were wires of partial funds that were sent out to Habib. I believe on 2 occasions, Mr. Habib, correct me if I'm wrong.
There was actually 3 wires that were made in relation to this lease. We would not accept partial payment, and so we immediately returned those wires.
And Your Honor, based on the partial payments, again,
hang on. I have invited y'all to have a conversation, but now we need to back up a little bit. And I'm going to let Mr. Habif's lawyer talk for a bit, Mr. Reynolds, because I gave you a little bit of time too as well. So go ahead.
Your Honor, acceptance of partial payments in dispossessory actions, or generally speaking, in landlord-tenant disputes, while non-payment is the issue, forfeits the landlord's right to continue with getting a writ of possession. And that is, again, in case law 115 App 18, 156 App 764.
No, I understand that, but you haven't, that's actually not my question. My question is dollars and cents. How many payments have been made to Habith that were actually funded and received or actual available to Habith to receive? I understand your position is they rejected them because if they accepted a partial payment, that might jeopardize their ability to claim their dispossessory right. I understand that, but that's not my question. My question is how many payments were actually made and funded that Habith could have kept if it had chosen to?
That's a question for Mr. Habith. Mr.
Mr.
Habith, would
Habith?
you share with the court how much in total for this particular place? Because the tenant has a separate premise with Habith Properties as well. But for this particular location, how much and how many wires were sent?
There was one wire for $30,000, one wire for $10,000, and one wire for $500, all of which were returned.
And how much was that total if you were to add that up, Mr. Habith?
$45,000. Excuse me,
Hang
no,
on.
no. $40,500.
When you say they were returned, do you mean by you because they were partial payments, or do you mean they were returned as insufficient funds by the financial institution?
We advised our bank not to accept them and to return the funds. So it would not be, perceived that we were accepting partial payment.
I understand. And so the order that was entered back in June or maybe July, I forget. I'm sorry, it was May. It had the dollar amount was about $24,000 that was owed in back rent at that time.
Actually, Your Honor, that's not correct. That's what Mr. Wimberly needed to file with the magistrate court in order to get his appeal.
Right,
that is a
which
check that was returned NSF.
Okay, so the way that the orders work from the court, from the magistrate court, is whether they're right or wrong, they make a decision that the amount of back rent owed is X, and you have to pay that amount in order to retain possession. And then you have to pay the monthly rent that's due each month going forward. And any month that you don't pay, you are subject to an immediate writ of possession. And so even if that's not the right number, according to your calculations, that's the amount that the Court of Appeals, the magistrate court judge said he owed and had to pay into the registry of the court in order to maintain possession of the property and his appeal. And then he made, as best I can tell, he made a payment of about $16,000, and that's the payment that was in NSF. Is that not right?
That does sound accurate. Unfortunately, when the magistrate judge issued the judgment, she was only calculating it off the base rent and not the base rent plus the operating expense, and that's why it was lower than it actually was.
Mag courts routinely deal with dispossessory. They're experts in it, but they're usually dealing with residential dispossessory, and commercial dispossessory gets a little bit complicated. So I understand that might not have been the total amount that you were claiming, but it was the total amount that he owed according to that judgment, and then rent going forward on a monthly basis.
Correct.
Okay. So how much, why did if we know, Mr. Reynolds, was it an agreement between the parties? Did Mr. Wimberly only pay $16,000 into the court registry instead of the 24?
Because he was paying the landlord directly for the amounts that were in question. He, pursuant to the agreement that they had, he decided to pay the landlord the full amount. And he did not only pay the 40-something thousand, he paid the full 63,000. Again, I can, if you don't mind, just briefly, I can go ahead and show the court all the different payment dates. There was a payment on the 11th, which was for 23,000. There was a payment for 30,000 as they've acknowledged. There was another payment, so that's already 50-something thousand. And then there was a $10,000 payment, which is acknowledged.
That's actually not accurate, Your Honor.
Well, hang on, Mr. Habeff, please don't talk over Mr. Reynolds. I understand if you disagree with it, make a note. But I was about to ask Mr. Reynolds, I do understand, at least from a reference that Mr. Namat Baksh made a moment ago, that there might be other properties that some of these payments are attributed to. Do you know, I mean, do you personally, Mr. Reynolds, have that information?
I do not.
Okay.
What I have is the confirmation that
These are payments that were made by your client to Habeff.
correct.
And okay,
Correct.
that helps me, but you don't know you don't have any information about what they're asserting regarding the whether some of this was for a different property.
Well, the information I have is that I don't see any reference to the email correspondence I reviewed and the text message communications I reviewed do not indicate that they are going to take some of these payments and apply them towards something else.
Okay.
It says you got to pay $63,000, and he's wired $63,000 over that time period.
Okay. Okay. Last question I think I have, Mr. Namat Baksh or Mr. Habeff. I understand that there were some payments that were received and returned. I understand there may be some issue as to whether they were intended for other properties that perhaps Mr. Wimberly may have, but how much money is owed on this property for back rent that was owed as of May of 2023, and then monthly rent, which the order that was entered by the magistrate court, the judgment, says that he owes $10,736 each month beginning June 5th. So by my calculation, that would mean, I'm not going to do the math, but that he should have made 3 monthly payments for June, July, and August, with another one coming up in September, in the amount of $10,736, and have already made a payment for the $24,317. Has Mr. Wimberly, how much money does Mr. Wimberly owe you for this property?
Your Honor, as of today, which is, September 1st, so September rents have rolled, the total is $95,834.14.
Mr. Habeff, did you have an attorney at the magistrate court?
No, we represented ourselves.
Right, and you're allowed to do that in magistrate court, but I remember that was a conversation we had at the injunctive hearing, is that you needed an attorney because an LLC can't represent themselves. Here's why I ask. The amount that is owed to the landlord and the amount that the tenant is required to pay each month was entered in this judgment, and Habeff didn't appeal this judgment. And so I question whether you would be entitled to recover that $93,000. And I'm just doing very quick math because I went to law school, not math school. But if he owed you $25,000 in back rent, and he should have by now made payments of $33,000 ish for June, July, and August, that's about $80-something thousand.
Judge Krause,
yes.
if I may, I do understand the court's argument pertaining to just, the procedural posture of the court order coming into Superior Court. Nevertheless, what we're asking is strict compliance of that same court order without excuse or delay for incomplete payments that were made to the register of the court or to my client within their time frame. So meaning, at the time, regardless of exactly if it was the full amount that Mr. Habeff would have been entitled to receive or not, regardless of that question, exactly how much that, math would come down to, Your Honor, there was a lack of strict compliance with that court order with the appeal provisions of state, laws of state of Georgia pertaining to how OCGA 744-754 interprets these kinds of actions. And in 266 App 34, Your Honor, the court determined that the courts lack the discretion to excuse a late or incomplete payment. So with regards to provisions of that same order that gave this same right to this tenant to come down to this procedure and use the Superior Court's protections, that same court order also protects Mr. Habeth with regards to this court not excusing or forgiving the lateness or incompleteness of those same payments. For those reasons, Your Honor, we are asking for the injunction to be removed. Now, whether Mr. Habeth followed the right process pro se and preserve his right for the entire amount, that's a different story. But nevertheless, it goes to the heart of this matter. But what we're seeking here today is more so on the tenant's performance of that same exact amount.
I absolutely understand that. The reason I was asking the question is if there's an argument here that payments have been made that were not accepted because they were only partial payments, what I'm trying to figure out is, has the total amount that Mr. Wimberly attempted to pay, does it total the amount that he was required to pay under this agreement? And if it does, would that satisfy the requirements of this judgment? Those are two separate questions, but that's what I was trying to get to the bottom of. Yes, Mr. Habeth.
Your Honor, I can shed some color on that. When we received the judgment from the magistrate court, that's good to have, but our main goal is always to get the writ of possession and to get the space back. The odds that we're going to recover that money after the fact, through a collections attorney are slim to none. So we are not, super honed in on the accuracy of that amount. It's good to have as leverage, but odds are we're not going to see a dollar. When we came before you the last time and we reached the agreement that Mr. Wimberly would pay that $63,000, that's because that's the amount that was owed at that time. And it was acknowledged by Mr. Wimberly that that was the amount that was due. And to speak to Mr. Reynolds' comment that was extraordinary and unreasonable, remember the physical eviction was scheduled for 9 a.m. the next day. So there was no reason why we shouldn't accept the payment in full because it was a 0 hour. I think it was unreasonable for us to, accept anything less.
Okay. Mr. Reynolds, I have sort of run all over both of y'all's efforts to present in a cleaner way, but if you would like to have a chance to respond, I will give you the floor for a few minutes.
Sure. The only thing I would say with regards to the attempts at full payment, he did actually attempt on several occasions to make the payments in full. We spoke initially about the certified check, which was not his issue or his fault that did not go through. Then he tried to do a wire. When he did the wire, it was returned basically because, or not returned, but it didn't go through for the full 63 amount because they said it was over the limit that he could have transferred at that time. He did try to transfer the wire. He had the money in his account and he tried to transfer it, but he got a notice that from the bank that essentially said, just give me one moment to pull this up. I apologize. I thought I had it in order. But it essentially said that it exceeded the amount.
I remember seeing that email and some of the materials that you had sent over yesterday.
Okay.
So I do know what you're talking about, that it exceeded. And I remember reading the reference and I was unclear if they meant it exceeded the amount that he could transfer in one wire or if it exceeded the allowable number of transfers, because I know that's also like if he'd done 20 already, he couldn't do a 21st. I know that's also something that financial institutions impose now. So. But
he did try to do it in full, and then he tried to do it in partial. The amounts have been there. He paid the amounts. They rejected them, except for the 23. They still haven't given them back yet.
And Your Honor, I could speak to that.
Yes,
if I'm allowed. There was a wire that Mr. Reynolds showed the screenshot for one wire of $23,000, another wire for $2,500. That was for payment for another account that Mr. Wimberly owed on. He has a separate lease for a property that is across the street at 1720 DeFore Place, and that's what that money was paid towards.
That might be what they tried to apply it to, but that's not his intent of why he paid the money. Clearly, those numbers add up to the 63,000.
Judge Krause, if I may, I think a lot of these comes down to he said, she said, whereas part of the evidence that Mr. Habeth has also provided this court deals with an investigation done by the Atlanta Police Department. There's exceptions to the hearsay rule that Attorney Reynolds stated that comes to be of significance. And if I may share my screen, I'm happy to show that to the court pertaining to the public records and reports, residual exceptions. We have, tried to get the investigators, the detective, to come to this court and share their findings. Nevertheless, this is an
Well,
active
I'll save you the trouble, right? So I saw the communication that was made to me about whether there were NSF funds paid to the clerk of court. I'm sure that's why APD is interested in doing an investigation at all. The nature of APD's investigation, I don't know what it ultimately will show.
Your Honor.
Mr. Habeff, I think I'm done hearing from everybody at this point. The reason I say I don't want to hear about that is because I don't have to believe it or disbelieve it to determine what is the appropriate course of action today. What I think is the appropriate course of action procedurally is that the order required that in order to maintain the possession, the possession of the property, the protection from dispossessory, Mr. Wimberly was required to make payments under the terms of the judgment. He did not make those payments. My understanding is that the party's original agreement for the entry of the injunction was to allow him to maintain possession of the property and to make partial payment up to a full payment prior to executing on the dispossessory. And so what all that means is this: the injunction that I entered was a function of an agreement between the parties, and that agreement no longer exists. And based on what I have heard, I don't have enough information to determine whether there would be an appropriate, whether either party is likely to, succeed on the merits, and whether any sort of injunctive relief would be appropriate. But you don't really. The injunction was essentially a belt and suspenders issue as far as I'm concerned, because if the payments are made, it acts as supersedious. And so what I think the most equitable thing to do is to say that the one, hang on, let me back up for a moment. Mr. Reynolds, I will say the one thing I am going to tell you that I do question is that in my life experience as an adult, granted, these are large dollar amounts you're dealing with, but in my life experience as an adult, it's not this hard to make a payment. And that if Mr. Wimberly really had the funds and was able to make the payment, he could accomplish it. My understanding is that the parties have a hearing in front of the magistrate court when?
September 5th, Your Honor.
That's Labor Day.
The
Is
Tuesday.
the magistrate court open that day?
That's a Tuesday, Your Honor.
That's the Tuesday, Your Honor, the day after.
Oh, thank you. Okay. I'm going to lift the injunction. I don't think that the primarily not for any of the reasons that the parties have given to me here today about this person did this, or this person did this. It's that my review of the record indicates that injunction was essentially an agreement between the parties to stay execution of the dispossessory while the parties worked out payment. And that agreement has fallen apart. And so there's no longer any factual or evidentiary basis for the injunction. And because I never heard evidence at that injunctive hearing, because there was an agreed resolution, there's no basis for me to either enter a new one or continue an injunction. If payment is made or could be made, then obviously the supersedious that attaches to the judgment might continue. But the real, the question I have is, as I understand it, the case that is pending in front of me is an appeal. And if the payment is not satisfied, then the appeal is dismissed, and judgment, execution on the original judgment is what then follows. And so the question I have is, I'm going to lift the injunction that was entered. The question I have is, I think what I'm inclined to do is to say that the court is going to dismiss the appeal.
Yeah.
Yes, sir, Mr. Reynolds.
I think in light of the good faith efforts that have been made by Mr. Wembley, as you can see, to try to make those payments and the rejection of them by the landlord in this case, I think it's only proper that he have the right to maintain that appeal. And if the court wants to say, hey, he needs to put this money in the court registry by X date, then please allow us to do that. I don't think.
Well, the court already did say that, and Mr. Wimberly didn't do that. And that's sort of what I'm struggling with. And I don't mean to imply that I assume it's not possible, but what I was about to say, Mr. Reynolds, is that I'm inclined to dismiss the appeal. But if payment were made prior to, I mean, this is all a holiday weekend and it's 10 o'clock on a Friday. But if payment is made by a certain time period, by X date prior to the hearing in the magistrate court, then the court won't dismiss the appeal. But if the payment isn't made in whatever form, and that would be a question we'd have to discuss, what form would that be? And to whom would it be? Would it be to the clerk of court, or would it be to Mr. Habeuf directly? The total amount, then that is the direction that I was going. But what are your thoughts, Mr. Novotny? I'm so sorry.
Niamat Bakhshian. Judge Krause, yes, yes, Your Honor. With regards to the appeal, we do believe dismissing this appeal would be the right course of action based on the failure to pay. Again, the law is very strict when it comes down to it. I stated some case law on this, 266 App 3437, 596 SE2D 209, OCGA 44-7-54. The provisions of the law that deal with appeal look at the payment as the ticket for the tenant to stay in possession, as the ticket for the tenant to continue on appeal as to the issue of possession. Once the tenant fails to strictly, comply with it, at that point in time, tenant waives their right to it. There's no more fight to be had over dispossessory as to the issue of possession. As to the judgments, if Mr. Reynolds' client wants to pursue a lower amount owed, then that leaves the possibility of Mr. Habeuf also as a de novo appeal that these cases are looked at, also pursue a higher judgment than what the parties previously agreed on. Nevertheless, we would move for the court to dismiss this appeal on the grounds that when we do show up to the magistrate court, having specialized in this body of law, I just a little bit concerned about magistrate courts, judges feeling their hands a little bit tight coming into a case that possibly has an appeal still lingering around. So we would appreciate the dismissal on that grounds. And ultimately, again, if Mr. Reynolds, upon the ruling on the 5th, if they're not happy with it, they have the right to appeal that again. And the process can possibly move on with, another appeal of that same decision.
Mr. Reynolds?
I just think it's in light of the fact that he has made the payments again, it doesn't seem appropriate for us to just dismiss his appeal now. I think the court was on the right track by giving him the opportunity to make whatever payments they claim are outstanding at this point in time, because he's shown that he has and will make those payments. They were rejected. You can't, on one hand, say that payments have not been made and penalize him for that if not paying into the registry when the parties had an agreement to pay the landlord directly, and he did so and they rejected them.
Judge, at any point they could have filed a motion to pay to the register of the court, got an order from this bench, and follow through with payment to the court. They never did that.
That's true. But you guys also allowed by agreement, which is when I entered the injunction, y'all allowed by agreement him to pay a lesser amount than was owed. And then there was some negotiation about him paying you directly. I think what I'm less clear about is I'm not entirely sure that the magistrate court, that's why I question whether the appeal should be dismissed or not, because I don't believe the dispossessory law refers to a court of competent jurisdiction. And while, of course, a magistrate court is a dispossessory court that has jurisdiction over dispossessory, once an appeal is filed, I'm not sure they do. But Mr. Reynolds, I feel like the right answer here is what I'd said before. Number one, I'm going to lift the injunction. And I'm going to ask that that Mr. Habeuf's counsel prepare a very brief order and submit it to Mr. Freehoff by in Word format by email. That lifts the injunction for the reasons that I just outlined a moment ago. I am going to the order that I'm going to enter is going to say that, Mr. Habeuf, tell me again the total amount of money that is currently owed to you by Mr. Wimberly.
For this lease, $95,834.14.
What time is your hearing on?
On September 5th, Your Honor, it's 9 a.m.
9 a.m. Okay. If Mr. Wimberly makes that payment in full, and I will say he can either submit it to Mr. Habeuf directly, who will certify that it was made, or to the clerk of court by 9 a.m. on September the 5th. Is that what it is? Again, Mr. Reynolds, I understand the how ridiculous that sounds, but I mean, I do. But at the end of the day, as I said, this argument was being had in July and it's September the 1st. And if he made those payments and they were rejected, then theoretically still has that money, right?
Yeah, that's not the issue. It's not the issue about whether he can get the money in. It's the question about he's traveling now, traveling internationally. The court knows that now. And
Right.
And we're talking about 9 a.m. Monday and he's out of the country. I mean,
It's Tuesday actually, but
same. I mean,
Monday's a holiday.
It's the next business day. I mean, Superman couldn't pull that off.
So I'm not trying to be overly punitive,
I know.
but as
wanna-
I understand it, Mr. Habeuf, your intention is, tell me what your intention, is it a new dispossessory pleading that you're planning to file in magistrate court?
I
Your
can
Honor,
answer the question for Mr. Habeuf, Your Honor, if I may. The intention is possession of the premises, continuing
understand.
the same action that was there. They had alpha eviction ready to go with regards to getting back possession. So their main intention is to get back possession as soon as possible, to also avoid some other possible issues that may come for other co-tenants, or just generally speaking, management of the property by some
Okay.
people that are going on.
So here's why I asked that question and why I mentioned earlier about jurisdiction. My understanding is that once an appeal is filed, I am the court of competent jurisdiction. And that if Mr. Wimberly doesn't comply with my orders, which would include the requirements of the judgment and the notice of appeal, that I have the authority to issue a writ of possession in stanter. And if I do, then originally what the court had suggested to the parties was that we would have a hearing with you guys on, I think, September the 7th, maybe, which is next Thursday. And what I'm wondering is, and that's why I asked, if you're planning to file an entirely new dispossessory action and start over again, that's a different issue. That's for something for y'all to decide. But if what your intention is to go back to the magistrate court and say, give us the dispossessory because we have this judgment, I can do that. And so what I'm wondering is, if the answer isn't, the injunction is lifted. There's no protection from dispossessory except to the extent of the supersedious that would be made, that would be affected by a payment in full. But Mr. Habeuf, I will tell you that the payment in full, I would require is I'm going to have to do that math, is the amount of the judgment exactly, which is the $24,000 plus the $10,700 payments that should have been made. And it will be 4 of them, right? That should have been made on June 5th, July 5th, August 5th, September 5th. And so what I think I would like to do, and I can't tell you that you can't go to the magistrate court, but what I can tell you is I don't think that you need to. And I think that if you go, they're going to say, well, there's an appeal pending. And I can accommodate y'all for the exact same reason on September the 7th. And that would be a slightly more realistic ability for Mr. Wimberly to try and make this payment happen if it can happen. But whatever happens, it's going to happen and be proof worthy, if that makes sense. So here's what I'm going to do. I'm going to do the math. I'm going to send an email. Mr. Freehoff is going to send y'all an email, and this is what my order is going to say. My order is going to say that Mr. Wimberly, I'm lifting the injunction, but that he may not be dispossessed if no later than 5 p.m. on September the 6th, which is, I think, a Wednesday. Let me look at my calendar. Yes, no later than 5 p.m. on September the 6th. If Mr. Wimberly makes payment in full in that outstanding amount and I'll give you the amount. I'm going to do the math and y'all can check my math. If he makes that payment, then his notice of appeal continues and he would be entitled to continue his possession of the property. If he does not make that payment, then the court, we're going to schedule y'all for a hearing on that day on September the 7th, which was what I had originally offered, would be y'all would come in, and if payment has not been made, the court will grant a writ of execution or the writ of dispossession that allows y'all to execute on the possession of the property. That's what I'm going to do. Can y'all live with that? I know everybody should be a little unhappy with what I just said, and usually that means I got it somewhat right if that's the case. But can y'all live with that outline, Mr. Nabat Kash?
Your Honor, our arguments with regards to this, I do believe the court wants to go based on equity. However, it would be a little bit unfair to my client in the sense that some amounts that Mr. Reynolds' client had already agreed on paying would be overlooked by virtue of going based on.
I understand that, but that's the function of an agreement versus the function of a court order. And the court can only enforce the judgment. That's what I'm being asked to do. A writ of dispossession is an execution on a judgment of dispossessory. And the judgment of dispossessory is this is how much was owed. And there's not an appeal pending for that amount that I'm aware of.
I understand, Judge Grass, but then on that basis, OCGA 44-7-54 would have obliged the tenant to pay within that 7-day period from a few months ago. So this, in essence, gives them a much longer runway to pay that.
I understand, and I agree with you that it's not fair and it's not the most ideal outcome. But it is the best outcome I can give you, because what happened is the parties attempted to negotiate, and Mr. Habeth, maybe his perception is that he got sucked in by agreeing to negotiate with Mr. Wimberly so that Mr. Wimberly secured for himself this longer period of time. Maybe that's what happened. I don't know. Maybe it was good faith negotiation because Mr. Wimberly believed that he'd be able to come up with the money and made efforts to do so. All of the facts I've heard here today could be characterized in either of those ways. And I don't have to decide which way to characterize it, but I also can say that the best relief you would get if I don't enter an order is on September the 5th, you would get a writ of possession and the ability to enforce the judgment that's already owed. And what I'm telling you is if you don't get that money by September the 7th, I will give you the exact same relief that you would get in the magistrate court on September the 5th.
I understand.
And so that's going to be my ruling. As I said, I'm going to send an email to y'all letting you know what my order is so that y'all will be clear on what the direction is while we get an order on file. But if you could send me a draft order, very brief, very vague, just something that I can edit and get on file for you today as soon as possible, we will do that. And then Mr. Freehoff will send you the Zoom link or whatever information we need to provide to you for the September 7th hearing. I think it's at 9:30.
9:30 in the morning, Your Honor.
I think so, yes. Mr. Freehoff, is it at 9:30?
Yes, Judge, things begin at 9:30.
Thank you. Yes, Mr. Reynolds?
There's only two questions I have about this.
Yes.
And I appreciate the judge for trying to figure out how to split this baby, like Solomon in this case. But I really have some serious concerns about whether or not that is accomplishable, given the fact that he's out of the country right now. I don't know if we're just setting him up for something that's impossible for him to meet in this scenario.
I understand, and I know it's difficult, but it also, to Mr. Habeef's point, is this all happened in May, and it's since July, and it is in this day and age of electronic transfers and wired transfers, and especially when you're dealing with money at that level, they're typically, actual people you can talk to that can assist you in accomplishing these things. Me personally, it might be slightly more difficult to accomplish from out of the country, but in this day and age, I don't know that it is, disqualifying to be out of the country anymore when you're trying to move money. It's just, it's too easy to do nowadays on your phone or on a computer, et cetera. So
That's just the amounts in question.
I understand that. And I absolutely understand that, Mr. Reynolds, but the issue here is I'm not making a judgment that anything that Mr. Wimberly did was intentionally misleading, but there's enough here to question, at least on certain occasions, whether his efforts to make payment were intended to look like efforts to make payment when he wasn't actually able to make the payment. And because of that history, that's why I think it needs to happen now, or that will be the end of it. And of course, you guys can continue to negotiate. And if y'all come up with some other better way to resolve it, then I encourage you to do so. But the best way that I know how to resolve it at this point is what I've just outlined, and that's what I'm going to do.
Okay.
Thank you, Judge.
Fair enough, Your Honor. And the second point I had was related to the amount.
Yes.
I want to make sure that $23,000 wire that he's paid, that totaled the 63 that they had agreed upon, is included, because there's no evidence presented that it should have been applied towards something else. The most likely scenario is that, again, because it totals that 63 amount, that was intended to go towards this property.
Your Honor, I could speak to that.
Okay.
So when we came to you before, we stated that the amount owed to stave off the dispossessory, to stave off the eviction, the physical eviction, we required an amount approximately $88,000. About 25 of that was for 1720-4. About 63 was for 1735-4. So when you reference we, negotiated a lesser amount, we were just kicking the can down the road for 1720-4, but requiring the full payment in full for 1735-4.
Hang on one second.
When
Sorry, I'm in my chambers alone, and all of a sudden somebody walked in, and I was like, "What is happening?" Anyway, go ahead, Mr. Reynolds. I'm sorry for the interruption.
I was.
And Mr. Habeef, you were explaining to me about the $23,000. I'm sorry.
So when we accepted the certified check from Mr. Wimberly for the $63,000 approximately, that is the check that was originally returned NSF. And that is the check that's being investigated by APD, not the check that was paid into the Court of Appeals that was also returned NSF. The reason why the check for $63,000 drawn on Navy Federal is being investigated by APD is because there is very strong reason to believe that is a fake check.
I have read the materials that y'all submitted to me, and I understand that is the concern.
And I know, and I understand that we're not going to have any rulings on to that effect today. But we would have, and again, that's one of the reasons why we would not accept wires in partial amounts from Mr. Wimberly. Once we realize the possible extent of that this was no longer a issue of non-payment, that this was an issue of out and out fraud, we would have major concerns about accepting any other form of payment from Mr. Wimberly. And our goal in all this is really just to cease all business with Mr. Wimberly and to gain possession of the space back at this point. We do not want to do.
I understand, Mr.
Wimberly
Habib,
at any
but
point.
you've now ventured past the point of explaining to me what the issue was with the 23 and
Mhm.
arguing your position.
Okay.
So my math is that according to the judgment, if the judgment is enforced by its terms, which is what should be happening here, Mr. Wimberly, as of now, which would include payment for September's rent, right? Because it's due on the 5th of each month, is $67,261.45.
$67,245.
$61.45, which is 4 months of rent for June, July, August, September. And then the back rent that he allegedly owed as calculated by the court of $24,317.45.
Last amount, 23,000.
24,317.45. And just for y'all's benefit, all I'm doing is reading right off of the judgment that was entered by the magistrate court on May 17th of 2023.
And Your Honor, just so that I drafted the proper way, the judgment or the order would read as $67,261 to be paid on or before September 6th, 5 p.m. There's a hearing scheduled with September 7th, 9:30 a.m. And
Yes.
ultimately, the injunction was by virtue of the parties' agreement. That never happened. Payment never happened. That injunction is lifted, and should the payment not be made, there will be a writ of possession issued on or after that 5 p.m. September 6th. And
That's
payment
correct.
is $67,261.04.
Yes.
I got it, Your Honor.
Okay. Okay, that's going to be my ruling, and I will see you on September 7th at 9:30. Hopefully y'all will tell me that this was all worked out and everybody payment was made and everything is fine, or you will tell me that Mr. Wimberly has voluntarily vacated the premises and all is worked out. And either way, we should be able to move past this point and figure out where we go next. Thank you all for your time, gentlemen.
Thank you.